Hello everyone, welcome to LexTalk World Talk Show presented by ClickAway Creators. Today we have Ms. Neeha Nagpal with us. Neeha is a graduate from University of Warwick, England, where she studied law and business studies. From there on, she went to do her LL.M in International Economic Law at the University of Warwick itself. Neeha has obtained a certificate from NotJustLEx for a course on private equity law in India. And being enrolled as a lawyer in India for over a decade now, Neha has vast commercial law and litigation experience at the Supreme Court of India, various high courts, National Company Law Tribunal. Neha has also advised clients in transactions relating to restructuring of companies and media TV show productions. She has worked on several international commercial arbitration representing the SR Group as well as various telecom companies. So, Neha, first of all, hi, and thank you so much for joining us.
Thank you for having me. It's indeed
Yeah. So Neha, can you please tell me something about yourself, like a bit about your journey and experience?
I just start with saying that I think I've been very lucky and I'm really grateful for the phenomenal journey I've had. At a very young age, I got the opportunity and had the experience of working on some very critical and defining legal cases. And I got to play an active role in those matters as well. And it's really made me today the lawyer I am and the human being that I am. In addition, I think I must mention one gentleman who's really played a father figure in my life and also, defined my mindset a little bit, which is Mr. Arun Jaitley. I'm very blessed to say that I've grown up under his aegis. He was a very, very close friend of my father's. And after my father passed away in 2009, he stepped up to, till, of course, his demise in 2019, stepped up to play a father figure in my brother and my life. And he's, at every stage of my legal career, advised me like a parent and mentored me. And I'm very grateful for that. I think for me, the most defining, there have been quite a few defining cases in my life. The 2G trial was something which I was emotionally vested in because it was just prolonged such a long period of time, and all my clients became members of extended family, and the learning curve was so steep, right from the investigation stage to the filing of the charge sheet, to the argument on charges, and data management, document management was one huge part of it. And the legal research and so many different aspects of law. It was right from criminal procedure to really what makes the ingredients of an offense, to corporate law. It had everything that one could think of that could encompass, and the whole strategy bit of it. How does one go in for a cross-examination, whether to lead evidence, whether one of the accused person should step into the box as to give witness, be a witness. So it was very, very fascinating, I think, and very few can say they've seen a trial from end to end, and that too in such a sort of eye-catching breaking news kind of matter. So that was one very, very very steep learning curve. But where I think where an emotional chord struck was the 377 decriminalization of homosexuality matter, where I was not just representing the issue, but also representing one of my closest friends. And in fact, he became, like the beacon for this entire movement at a point. And this whole petition started as a dinner table conversation with him, and which really saw the face of the homosexuality laws in this country changing thereafter. And it was something that was done from a place in the name of love, for people who were fighting for their right to love. And just the warmth I received from all and beyond after that was phenomenal. It just makes one realize that as lawyers, we are at a place where we can make a difference, and we should make a difference. And we should make every endeavor, not just to earn the money, the reputation, but also to genuinely make a difference. I think, yeah, that's been the sum of the wonderful, short and wonderful journey I've had so far.
All right. And Neha, you were also awarded the First Icon of Tomorrow award in 2018.
Yes. It was a great year, 2018, and it was definitely. I actually felt really. I always wanted to get a Forbes 30 under 30 award, and I didn't make it that. But then it didn't get better than the Forbes Tycoon of Tomorrow because it was a more futuristic award and not just limited to a particular age band. But it was definitely a very satisfying moment.
Exactly. So now, without further ado, let's dive into know more about her. So, firstly, I would like to know about any complex legal issue that you worked on, and also describe the complexity and tell us how you approached it.
So I think as lawyers, every day we're dealing with something very complex and very difficult. At least the area of law I choose to practice, which is white collar crime and insolvency. Every day one is tackling, shooting from one issue to the other. So in recent times, there have been two rather complex issues that one has handled. One was for a real estate developer who was taken into insolvency, and Section 7 of the Insolvency Act had recently been amended. Sorry, the IVC code had recently been amended to include that if a real estate developer has to be taken into insolvency by a home buyer, it needs to be either 100 home buyers together or 10% of the total project. These two home buyers had taken my client into insolvency and got them admitted into insolvency. So the bigger situation was there's a very limited scope that one can go in appeal for. Even though they settled the matter, but the NCLAT said we're not getting into the settlement because COC is formed. Then we had to nuance an argument, which was a very it took a really keen understanding of the code that these two home buyers cannot come forth as just home buyers, have just not come forth as home buyers, they've also come forward as decree holders. Can a decree holder who is a home buyer also file an insolvency petition? This finally NCLAT held that a decree holder does not become a financial creditor. They may be an operational creditor, but they're definitely not a financial creditor. So therefore, that petition was, our client was taken out of insolvency, and the NCLT judgment admitting them into insolvency was overturned. So that was one very defining moment, and it sort of laid down the legal issue on this point. Another in recent times, in fact, on the 10th of August this year, I had a senior citizen client who'd been arrested by SFIO. As you are well aware, SFIO still has the twin condition of bail, which basically says that the prosecutor has to be heard and the judge has to come to a finding on merits that no case as alleged or otherwise is made out. And this gentleman is 65, has a whole lot of medical issues, and he was arrested just one day prior to the initial lockdown in March 2020. So he'd been in jail for a year and a half. Charge sheet filed by SFIO, complaint filed by SFIO, and no trial has started. And his health was just dwindling. And so we finally had, through the process of the law, we finally reached the Supreme Court. And just the manner in which we were able to put his case forward to the Supreme Court with all his medical records and also on the merits, and to be able to get him bail was a huge accomplishment, I felt, because this was a bona fide case of bail, and it was also a place where you can't keep somebody in custody pending trial. So it was these were two complex issues, and I think a lot of it is also about when one is dealing with such complex issues at a human level, and even as a lawyer, it's very important to stay calm, because best legal strategy comes from a place of complete calmness and to know your facts in and out. So you only devise a strategy when you know all the odds against you. Like they say in cross-examination, never ask a question to which you don't know an answer. So I think you have to really hedge yourself before planning a strategy. So it's about knowing all the risks, staying calm, and staying focused on the ultimate goal.
All right. So now that we are still in between the pandemic and we have a new variant around the corner, so I'd like to know, the pandemic saw some courts begin moving towards more remote proceedings and availability. Is this sustainable and a possible way to increase access to justice, in your opinion?
Well, so the thing is, the technology is here to stay. whether we there is a hung house, I'd say, in a way that there is some sector of lawyers who are not very comfortable with it, and there are those who've taken to it very well, because it definitely it sort of the ease and the speed at which one can operate and function is phenomenal. I'll give you an example. Through the peak of the lockdown last year in March, April, May, we were filing petitions day in day out, and in the High Court. And I thought that way of filing was the best way of filing, because it was all done online. And as a lawyer, I often feel very guilty for the paper we waste, the environmental damage we do. And literally at that point of time, it was a delight to be filing petitions, because you weren't wasting paper. It was all so much faster. You literally had to just collate a PDF, number it online, through the, of course, the software, and email it to all and sundry, and everybody was using their laptops, iPads, and reading petition online, marking, bookmarking, and it was all seamless and good to go. That saves on time, that saves on environmental damage, that saves on the speed at which things happen are is a lot faster. So I think technology is something which is wedded to the legal profession, and the more we accept it, the better our lives become. It's literally like the old days way of research. You used to go through books and books and reams of books, and today you have SCC online, or you have other search engines which really give you a more honed research, advanced research skills. So I think it's here to stay, and the more we accept it, the better it is for us. And even logistically, if you see, on a Monday, Friday, every court in the Supreme Court has over 15 matters. It's insanely difficult to even make your way into a courtroom on a Monday, Friday in the Supreme Court. It's a question of the large numbers, and I feel with an online system on miscellaneous days, what happens is that it's the waiting time is cut down. The mad rush of rushing into court and pushing people and being rude in a manner of speaking, not willingly but unwittingly, is all taken away. It's just more efficient, I feel.
Right. So now I would like to ask you, what according to you are the gaps in the legal system resulting in delay of disposal of cases, and how can that be bridged?
So, what I've learned from a few international arbitrations that I've done is that before the tribunal starts the matter, there's 5 minutes or 10 minutes allocated to a housekeeping list, which includes also laying down strict timelines for when submissions will be filed, when opening the number of days each party needs for an opening submission, for a closing submission, the number of days they need for examination of a witness, and they stick to that deadline, the timeline. I think that's what we need to start doing with major matters here, and unnecessary prolonging arguments, the same point being repeated by various respondents or petitioners. It just consumes a lot of judicial time. And that should, once courts become very rigid about, I can't even say exactly rigid, but strict is probably a more appropriate word about the timelines, then we can bridge that gap, and therefore resulting in, for higher rates of disposal, lesser pendency. And of course, an enabler to all of this is technology. So yes, I feel welcoming technology, becoming more conscious of the need of speedy disposal. Of course, we are conscious of it, but actually doing something about it by curtailing our own arguments would probably help.
So, in the era of legal technology, what are the most common used tools for you?
I think I can't do without my calendar. It's very, very important to have my cloud-based calendar. Of course, the use of calendars has been since pretty much the legal profession started, but back in the day, it was obviously a little pocket diary. But my legal calendar, which is on my phone and laptop and iPad, it's very, very important. I'm highly dependent on it. It just helps you plan your day better. plan meetings better, plan even preparation time better. Another tool I can't do without is definitely my iPad and iMac and my laptop. Um, the softwares I use or the sort of apps I use are PDF Pro, PDF Expert, Liquid Text. It's very useful to make notes. So yeah, those are basically the tools that I'm dependent on. And of course, then there's the search engines that one really is dependent on to be able to get faster case law research. I try and dictate when I normally try and type myself in Touchwood because of I studied at the University of Warwick, and it was a lot was about our long dissertations and long essays. So I got used to writing 5,000, 10,000 words, typing it myself, because back in the day we didn't have dictation apps. But now Mac has an inbuilt dictation app, though of course one has to train it, but I'm getting used to doing that, so that also saves a lot of time.
Right. Now, as a saying, time is money defines the legal profession most suitably. Do you subscribe to that adage? And how do you choose to make a difference in your legal practice?
Time is money. Actually, I don't know. I do think that time is valuable, because time once lost never comes back. But time is money. No, I think time is so much more than just money. And it's unfortunate that a lot of people look at lawyers as people who think time is money. But no, I think we're slightly more sensitive than that. We're slightly more humane than that. Once you have a realization, and I'm sure a lot of us have, that as lawyers, you really have the power to make, or the ability, not even the power, the ability or the voice to make a difference, then it's not just about the money. Yes, I choose to make a difference. I want to make a difference. And wherever I can, I do try and do as many pro bono matters as I can. I work with this charity, which is a home for acid and rape attack victims. Wherever I can help them, I try and help them in whatever manner. And I'm also trying to get together sort of a tech learning or tech enhancing little program with this edtech platform for clerks. So just whatever little bit one can do, and it takes a journey of 1,000 steps begins with one. So whatever I can put my best foot forward to help, I'm always happy to do that.
So thank you so much for sharing such great insight with us, and we look forward to having a chat with you again in the future on some other trending topics in the international legal world. So for our viewers, if you like this chat with Ms. Neeha Nagpal, please like and share this video as much as you can, and also subscribe to Clickaway Creators YouTube channel to appreciate what we do, and you have more coming from the legal space. So this is Nikhil for LexTalk World signing off.